Thank you all for joining us for the penultimate session of the Colaba conversation. My name is Trisha Ray, and I'm an associate fellow here in the Tech and Media program at ORF. We live in the shadow of tech giants. These digital multinationals have ushered in a new era of connectedness and innovation, but they are also increasingly criticized for anti-competitive practices, at the disadvantage of small businesses, for turning their users into products with adverse social and political consequences, and for their apparent lack of accountability to their consumers and to countries outside of the ones they are headquartered in. I'm joined today by a stellar panel of thinkers and policymakers with precisely 40 minutes to attempt to resolve these big debates. Her Excellency Marina Kaljurand, Member of European Parliament from Estonia, Dr. Rohinton Medhora, President at the Center for International Governance Innovation, Chris Painter, President, Global Forum Cyber Expertise Foundation Board, and Ivana McGowan, the Director for Europe for the Center for Democracy and Technology. We will kick off the discussion with a scene setter. The question is to all of you: should digital multinationals be more accountable to the laws of all sovereign states within whose virtual borders they operate? First, to Chris, your answer to the question.
Yeah, thanks. Well, the question is sort of yes and no. Yes, just like any companies anywhere who operate globally, they should be accountable. But the question is, what does accountability mean? And what do local laws mean, too? So there are certain local laws, obviously, that any of these companies need to comply with. But the worry I have is, how do we make that accountability work while we still drive the engine of innovation and connectivity that we've talked about, the benefits, and at the same time worry about conflict of laws? I think the worst thing that could happen, this is already happening, frankly, is a number of jurisdictions who have conflicting laws. So that creates an international environment that's not unified, that's divisive, that frankly, for some of these companies, it puts them in a bind where they could be arrested in one jurisdiction, another jurisdiction, by complying with the laws in another jurisdiction. So I think we have to have a global conversation about this. I also worry about, the last thing I'll say is, I also worry a little bit about some regimes for whom accountability means control, and control over content and free speech. Now, that certainly isn't democracies like the US and India, but certainly there are other countries who very much want to control content, want to control free flow of information. And it's not just the commercial speech they're interested in; it's that social speech, that speech that we want to encourage.
That answer very succinctly captures a lot of the debates we'll be having in the course of this panel, particularly around sovereignty. Marina, to you: should digital multinationals be more accountable to sovereign states?
Yes, I think they should, because if we see the development, some 10 years we had completely different understanding of the accountability of big techs compared to what we have today. So yes, I do think that we need better regulations. I do agree with Chris that we need better global understanding and global regulations. And here, coming from Europe, not a surprise that I say that we are very good in regulating. We have the example, for example, of GDPR, the data privacy of EU citizens, which is an example of regulating difficult, sensitive topics. We were severely criticized when GDPR was adopted, but now I would say it's a global standard. So yes, I think that also with the new legal documents we are working on, being the Digital Services Act, the Digital Market Act, digital strategy documents, yes, we are aiming at setting new global laws, norms, and regulations.
Thank you. Next, Rohinton, what do you think about this question?
Trisha, I think the answer to your question is yes, period. Meaning, of course, multinationals historically have operated in different jurisdictions with conflicts, and the way you do that is you start by saying, especially in an area like data flows, in which your health, your society, your democracy, your economy so function along these lines, they have to abide by national regulation. Now, national regulation works best when it's backstopped, as the other speakers have said, by global cooperation. And the most obvious example that comes to mind is something like taxation, where if we had a globally harmonized regime, if we actually took care of the tax havens and the fact that multinationals disproportionately declare their income in some jurisdictions and not others, then we've got the perfect system. But that's not the same as saying, therefore, let's look at it from the point of view of the firms. We still have to think about countries and nation states as being sovereign. I'm also equivocal about this question of somehow it's different in democracies and we should be worried about autocracy. I think the fact is we have now seen, GDPR is making valiant efforts to change that. But we're now seeing that even in democracies, it isn't a question of citizens asserting their rights versus the government. These multinationals are large enough, and we know through their algorithms and through their participation in the political process that they can warp the information we see. And so the question of democracy is not something I only worry about in totalitarian states.
Thank you. And you preempted one of the questions I was going to ask precisely on how, in fact, I can ask you now, in fact, a continuation of what you raised about the tax haven question. Then how can the value that's generated by these giants contribute better to the economic growth of nations? And keeping in mind, of course, that companies may incorporate themselves in creative ways to avoid tax liabilities. What are some specific measures then that countries could take?
Is this directed at me again?
That's right.
Yeah, look, I think the OECD process is a good one. I think countries like France and the UK that tried to do it on their own, I think France's tax was particularly ill-designed, and so it was kind of shown up as almost being WTO incompatible. But broadly speaking, we need a multilateral process for this. We also have to understand that there are tax havens that have to be addressed. And by the way, this is nothing to do with digital multinationals. This is a long-standing question, the one of tax havens. And I think groups like the G20 have to come at this straightforward, because even before COVID, when government budgets were stressed, the fact is governments, let's put it this way, in the digital era, a lot of wealth is created through rent, and the rent is garnered by proprietary intellectual property. And so in the last 2 or 3 decades, the trend that we've had towards taxation of consumption, we're going to have to move back to a regime of taxation of profits. Profits taxes is what governments will have to address so that they can then provide the public goods that citizens expect of them. And so there's a series of public finance issues around taxation and spending that we might want to get into, but which I think is central to the way digital multinationals work.
Thank you, and thank you for taking on that slightly unexpected question. Ivana, should digital multinationals be more accountable to the laws of sovereign states, especially sometimes when it puts them at odds with the citizens?
So as an international human rights law expert, you'll be unsurprised to hear that I certainly think that companies should be accountable, as should states. I thought it was interesting, you mentioned the word sovereignty, and I see this in a lot of different ways. We should always remember that sovereignty is not state power. The power of sovereignty derives from the people, and the state having that sovereignty is contingent upon them respecting the rights of their people. And I mention that because sometimes sovereignty is used as a phrase to kind of backstop against any regulation or international oversight or interventions, and we need to really remind ourselves of the basics in some of these conversations. So I do think that it is certainly important that there is accountability, but I would, some of the speakers before had mentioned this tension sometimes between local laws and international laws. Given that we have seen, and I know we'll talk about this later, the increasing threat to democracy, whether it be the integrity of elections, whether it be regulation of speech online, it's really important that we think about international human rights standards, so that kind of existing international framework we have about constitutional laws, and thinking about how do we apply that. And the reason that that's so important is, as we've seen with the pandemic, there's no such thing anymore as the divide between the offline world and the online world. We're all living online, and we need our constitutional rights respected online. And of course, companies have a proportionate accountability in that. And I'm looking forward to going into more detail with you about some of our ideas about how getting that balance right might be.
Trisha, if I could just jump in on one thing that came from both of the last two speakers. It's important, I think, for us not to think of tech or online stuff as a wholly separate thing. Both with respect to the debates about taxation and regulation and human rights issues, we do have to think about it as part of the physical world, too. It's not such a different thing that has different rules apply, even though it's getting a lot of the attention right now. I think we need to make sure it's grounded in the way we deal policy on the physical world as well.
Thanks. So many of you mentioned the need for a more global governance framework and uniform legislation. One area we can look at, for instance, is data. Globally, numerous frameworks have emerged in the realm of global data flows. The Osaka track for one. So then, how can these approaches be harmonized? Certainly, there are a few common principles, but there do seem to be key differences that still need ironing out. Brendan, would you like to address that question first? Rohinton, can you hear me?
Yes. What was the question again, Trisha?
The question being on creating a uniform framework for global data flows. What would be some creases within that would need to be ironed out, because there are quite a few competing approaches.
This, I think, is the big sort of challenge in international cooperation. Elsewhere, I've argued that the first step might be to actually have some kind of global covenant around new technologies more broadly, and patterned on the Universal Declaration of Human Rights. The point being that we have to have a shared understanding of what data are, how they're used, to what purpose. Now, I know that there are many people who say that lots of countries have signed on to the UDHR and they have no intent of following it. And my response would be, we still need it, because it's citizens in oppressed countries that look to these kinds of beacons. But more importantly, this is what guides the drafting of national and subnational legislation. And also over time, as we've seen with the Hague Court, you can actually punish people who violate the convention. So we do need a global shared understanding of data. There are 2 or 3 areas that are vexatious on which I don't think there's a real answer, but let me just suggest to you that content regulation is one, and different countries may have different ways to approach it. Data localization is the other. Now, what's happening, speaking as a Canadian, is that through trade agreements and through the use of the safe harbor provision, the ability of countries to regulate content of platforms is being taken away. And similarly, the thou shalt not localize data dictum is being injected through trade agreements. Now, these are not trade issues. As I was saying before, these are very fundamental issues to our health, to our society, to our democracy, to our productivity. And so trade agreements are the imperfect medium through which a particular preference, in this case that of the US, is injected into global governance. I think we need to think of this differently and find different ways to do it, which is why I think having a much more dedicated conversation within the G20, or perhaps initially within a D10 and some other grouping, and then arrive at these things crab-like, is the way to go. But I do think questions around data flows, questions around taxation have to be addressed globally at some point. And yes, we do have 2 or 3 data zones. Of course, GDPR is the one that is or aspires to be the global standard, but we do have a firm-centric US zone and a state-centric China zone. And lots of countries like Canada and India do not belong to these. And so reconciling these different data zones is going to be the challenge as we go forward.
Thank you. Ms. Kalyan, in relation to this question, the EU has done a lot of work on the question of like rehousing data, rebalancing data flows in order to help like local industries innovate. And the EU passed the Digital Services Act and Digital Markets Act most recently. So how do you see, or do you see some common practices that may arise out of the legislation being passed at the EU when it comes to data flows?
Well, to start with, I very much agree that we need global approach. But at the same time, I'm not naive. I see how big ideological division we have globally. And unfortunately, we're using data for different purposes. And even in the cases when we say right things, we act differently. That's the reality today. And that's why I do believe that maybe some regions can be examples globally. And now I come back to the question concerning the EU. We have 27 different jurisdictions. And in spite of negotiations and trying to introduce cross-border actions and cross-border removal orders, it's impossible, even within like-minded 27 but different jurisdictions. And that's why I think that the efforts of working on European strategy for data, the aims are right. For example, to create by the end of this year health data space, to create by 2030 single European data space. These are the first steps that are being taken by the EU. So yes, I believe in the need for global cooperation, exchange of data, but it has to be safe and secure. And maybe now looking at Chris, unfortunately today we're in a position where we do not have legal ways of exchange of data with the United States, after the European Court of Justice has rejected all the existing. And very much being on the same page with Iberna, I'm in European Parliament in the LIBE Committee, Fundamental Rights and Freedoms. So these are the questions we're facing every day, how to do everything properly, legally, and not harm the fundamental rights of our citizens.
Thank you, Ms. Kaljuran. Chris, there was a point addressed directly at you. Would you like to?
Yeah, sure. I think the kind of basic concept, the watchword in all this is we're not going to get a globally consistent framework anytime soon. It may be something we want to aspire to and we should aspire to. But in reality, as Marina says, there are lots of different approaches to this. Each have certain advantages, or some have more advantages than others. So one of the key things is interoperability, and this is where the kind of equivalence agreement between the EU and the US is so important. We have to figure out a way that what we do in the US or what you do in India is consistent enough with what the EU does so you can have this free flow of data and information, and that's, I think, really important. And we have to address that, and I think there's an opportunity to do that with the new administration here in the US even more. I think to look at another area, and I think the Data Protection Act, GDPR, was really important in setting sort of a de facto global standard. I remember testifying in our Congress at one point, and they were saying, well, can't we tell the EU not to do that? And I was like, well, you could have actually come up with something on your own before, and you didn't. And in fact, this idea of a privacy bill of rights has still been kind of percolating in our Congress for years now. So we also have to take a leadership role if we're going to do that. But I also think we have to think about some of the unintentional downsides. When we think about these regulatory regimes, including GDPR, one of the issues is, does that make it harder for new entrants, smaller companies who can't afford the army of compliance lawyers and other things to deal with this? And I think we have to worry about that as we do it. And then the final thing I'll say is we've looked at this in other aspects too. So one big aspect, particularly with India, this is a conversation when I was in government I had with Indian officials all the time, was getting data from the U.S. with respect to law enforcement issues. Because a lot of data is at least currently held in the U.S., and I think part of the solution is in the long term, not all the data will be in one place. I think it will be spread around the world because more companies and more entities will come into this. But right now, a lot of data is stored there. And there was something that the U.S. did called the Cloud Act to allow access. Now, that's only been done with the UK so far, and it needs to be spread out to other countries. And there are certainly complications there. But we need to think about innovative ways in the short term before we get to that long-term giant agreement of everyone, which is still far off. to address these particular problems, like the law enforcement problem, like the data privacy problem?
Thank you, Chris. Ivana, that was a point to address to you as well. And in addition to the question on data governance, I would also like to ask a question. Would piecemeal regulation suffice when the business model of many tech giants is based on the monetization of user behavior and patterns, which often puts them at odds with the welfare of said users? Ivana.
Sure, we're getting all the easy questions today. Just maybe one point on, so from the Centre for Democracy and Technology, I head up the Europe office based in Brussels, but we also have an office based in Washington. So we are obviously following in great detail this conversation, almost a constitutional conversation that's happening between the European Union and the United States. And it again brings a little bit back to the first point, is that the European Court of Justice, in its ruling that it's very disruptive to many businesses, to our, even our ability to talk to our cousins and friends on the other side of the Atlantic. But what the European Court of Justice has said is that the safeguards, including a right to a fair trial, access to remedy in the United States, do not meet the equivalent standards in the European Union. So again, you can see that, and we've already been through this twice with two different privacy shields. It's clear that the European Court of Justice is now being quite unequivocal like that, which leads us to a new space. And my colleagues in Washington are also advocating for federal level privacy laws, indeed, because that could help solve not all but part of the problem on that side of the Atlantic. With regard to the use of personal data, and that is the big question, we know that the use of personal data feeds algorithms. This can be part of the problem about driving disinformation online. It can be, as we also know, misused in the context of elections to suppress certain voters, particularly from minority backgrounds. So, for example, in Europe, we do have GDPR, which limits the extent of personal use of data. But unfortunately, the enforcement of that, even in Europe, has not been strong enough to actually stop the extent of this problem. So we lack a bit of the evidence to say, if we continued, because obviously we're talking about a certain business model, if we had really rigorous full GDPR compliance, what would that look like? And again, I think often people confuse these conversations about regulating an element of speech without asking the more fundamental question about how personal data itself is driving content, algorithms, and spreading disinformation online. So they're really important. And I do think, with regard to the point made about smaller versus large companies, it's interesting that the Digital Services Act proposal, not yet law, in the European Union has actually made that distinction. So it's talking about, what do we do for smaller companies versus larger companies, but it's definitely a crucial. I also think it's a bit linked to the tax question, because the business model is we have free access to service, and obviously data is the commodity that drives some of the profits online. And then there's a question to say, well, if that was halted or significantly reduced, how could you still have enough money to give, to keep these platforms alive and online? So I think these questions are also inherently linked at that level. And it's not, some people talk about, paying for or about access to data, but we have to remember that people who don't have the economic means, it's essential that we give them equal access to the online spaces to participate in conversations like this one today.
Thanks, Savannah. In fact, there's a question in relation to what you just said from the audience. Do you think tech businesses paying users in some form for the right to sell or use their data might become a viable business practice as the rest of the world presses on good data practices? And what impact could it have on how we see data privacy now?
So I think we have to be very careful, because we've seen this, for example, in the case of health data, that there can be, it's a very valuable thing to say, oh, we really want to gather health data from data subjects because we want to do, a certain, for the purpose of a certain product or outcome. And again, what I would stress is I think that's it's a dangerous perspective, because we get into a situation whereby those who can afford privacy will get it, and those who can't won't. The idea that you really are selling your own data. So I think we have to be, it could obviously paying for applications more generally solves some of the problems with regards to using a data-driven business model, but we need to be very careful about this idea of buying your way onto the internet. That's something that I would be worried would disproportionately impact people who don't have the economic means, and we need to be careful about that. It shouldn't be, you can use my data or I pay you not to. I think it's been proposed by some quarters, but I'd be very worried. I think privacy is a fundamental right that shouldn't have an economic link to it.
There are two questions that I would suppose are related. One is, could regulation put the brakes on the digital economy? The second is the breakup of tech monopolies possible, and how would that be achieved? Chris, would you like to take this question first?
So, yeah, I mean, the answer, none of these are absolutes, right? So, regulation done the wrong way could have a bad effect. You have to do smart regulation. You have to think about, what are you trying to regulate? What are the goals? Are you trying to regulate any competitive behavior? Are you trying to regulate data? I'd agree with Iverna. I think that the worry about monetizing this is that, and one of my roles now is to promote capacity building, is to get more people to have access, and we want people to have access. So that's worrisome. The other problem with it is, how do you, in the aggregate, data is more valuable than it is in the individual. Like, one piece of my data is probably worth like 10 cents or less. So how do I aggregate that? So we talked about economic models, and those don't work very well. On breaking up tech, I guess, again, the question is, what is the tool you use and why? So if you're saying it's anti-competitive behavior using antitrust laws, let's look at that. It doesn't matter just that they're big. That's not the rule under antitrust laws. Bigness is not, against the law. If they do engage in any competitive practices, and there are certain arguments that they are, let's look at that. Let's address that. And I think that can be done and is being done to some extent. But I'm not sure breaking up is the solution. Part of the solution is to have more competitors in this field, and we've not been good at that. We need to have more folks in these fields, so you don't just have these big companies out there. And that's a hard thing to do, frankly. So I think we have to think about, how do you incentivize that? How do you create that? At the same time, how do you regulate the ones that are out there in a way that they're playing in a fair playing field?
Ms. Kalyan, would you like to address these two questions?
As to the question of regulation, I would argue that the European Union is known for over-regulating. And unfortunately, we see how startups, instead of going, from Estonia to Madrid or Paris or Berlin, go to Silicon Valley. So yes, we have, in some cases, we have over-regulated. I think we learned the lesson, because we lost the first battle of personal data. So with public data, with exchange of data between businesses, with voluntary access to personal data, for example, for health or research and development interests, I think we are now smarter. And that's why, for example, in the Digital Markets Act, there is a division between gatekeepers, those who have the biggest impact on the digital market, and SMEs, so that we try to regulate the way. We do not punish SMEs, we do not stop their development, we do not stop their businesses, but we keep them accountable. So I think that's the right approach, to have a different approach to platforms or companies, depending on their size, on their impact on digital markets, and keeping eye on gatekeepers. Keeping eye on, for example, there is an obligation for them to report about mergers and acquisitions. There is an obligation for them to moderate content without using automated filters, always having human oversight. So I think that we can regulate, but we have to learn from our first lesson and not to over-regulate. So less regulation is better than more regulation, and no regulation is better than bad regulation.
Thank you, Ms. Kalyan. Rohinson, in addition to those two related questions, since we have been talking about platforms disadvantaging small businesses, a question that I had circulated to the panel beforehand was that aggregators and platforms like Amazon and Google Search often engage in practices that may favor certain paying partners, but then disadvantage smaller businesses and content creators. So should platforms eliminate these preferential policies?
Look, I mean, I think we should not be making some false dichotomies, especially in the abstract. I couldn't say, for example, that bad regulation is worse than no regulation. In some cases, yes, I can think of cases where that's not the case. I think at the end of the day, what drives the kind of, if GDPR is seen as a bit of a global standard, but as we've pointed out, compliance costs fall disproportionately because they tend to be fixed, and so they fall proportionately higher on smaller firms than larger firms. And then the national data authorities also function differently. So even within a common jurisdiction, we have this issue. And so if you sort of break that out globally, then it becomes that much more complicated. Then the question becomes, how do we address what is essentially a market structure issue, which is that these are natural monopolies. The more data you have, the better your product is. The better your product is, the more customers you have, and therefore you have more data. And that's almost a textbook definition of a natural monopoly. Breaking them up is clearly not the way forward. But there's lots of regulation that can be done around content, around the de-identification of data. I think the concept of data trusts, where certain kinds of data are sort of voluntarily pooled and then used to a common purpose under a watchful public eye, is the way to go forward. I also think if you think that these firms are big, and yet they say they don't have the capacity to totally monitor their content, that's not something we're willing to tolerate when you buy pharmaceutical devices or fly on a plane. So I think there is a business model issue, is that if you fundamentally have a business model that's incapable of providing a safe product, then we should be looking at what is that business model. And so if large firms are not willing or able to do it, I'm not convinced small firms would be able to do it either. And this is a classic role for public intervention, for government. And I think just as we have found ways to regulate what used to be a very scurrilous press many years ago, we're going to have to be much more proactive on content regulation, on the auditing of algorithms. All the black boxes that give digital monopolies their monopoly power have to be pried open. That's not the same as saying it will always go well, but I think we have to try it. And if we shy away on the grounds that bad regulation could do harm, we leave ourselves open to the harm of no regulation. And we're living that, by the way.
Yeah. Ivana, the question goes to you.
Certainly. So something that I feel very passionate about is that a mistake that's sometimes made is that in order to respond to a societal problem, we can see, politicians and others coming up with a new regulation without really interrogating how our existing laws and other instruments that we have are being used to solve a problem. So I'll use artificial intelligence as a very concrete example of that. In the European Union, we have very strong, it's still incomplete in some areas, but very strong laws on equality, in particular for access to employment. We know that AI is being increasingly used in recruitment, and we have very strong regulation that there's a burden on those who use, those who make a decision about employment have to disprove discrimination. So there's already a very strong legal basis that you have to unpack and explain that black box and a criteria for what that looks like. But I think instead of getting into that, concrete example and looking at the specific societal harms, there's a tendency to zoom out and generalize and say we need to regulate AI. I think we need to be really specific and purposeful and say, what are the rights being harmed? What is the impact to democracy? And then look at our existing frameworks and challenge, are they being enforced? are our governments, frankly, technically savvy enough to enable that? And I guess the area where regulation can often be most useful, and it was mentioned by other speakers, that in order to audit an algorithm, you might need a mandate in law to ensure transparency and access to that algorithm, and of course an independent oversight body in some way that could carry that out. So I think we, again, need to be quite specific, not saying generally about regulation, but really look concretely at what are the harms or the problems we're trying to solve, what's the existing framework, and what's the piece that's missing in terms of making those rights a reality in the digital age.
Thank you. So there has been an interesting case recently with Australia passing the Treasury Laws Amendment, where they essentially would enforce that, like, Google would pay news organizations based in Australia for the content that turns up in their search. Google then said that they would pull their services out of Australia, to which the Australian Prime Minister responded that they do not respond well to threats. So this is one case in which the business side of tech giants comes directly at odds with value creation, as well as the sovereign right of a nation to regulate the way content or value is generated in the country. So in situations like this, is there a need to rejig our understanding of how value needs, or how value should be created within this, like, influx framework of the way tech giants create? Rohinton, over to you.
This circles back to your first question on national sovereignty. So here you have, we're not talking about China here, we're talking about a democracy, Australia, and the government, through its political process, came across this way, and a foreign multinational sort of threatened to pull out as a result. One answer is to say, well, we live in a free world, feel free to pull out. You don't have to do business in this country if you don't like the way our laws operate. The more realistic way is to say, then there's room for negotiation. And it seems to me, when, as with the French digital tax, when one country tries to do it on its own, even a large, powerful country like France, or an advanced one like Australia, it tends not to be a particularly level playing field. But if groups of countries set about and said to Google, actually, you know what? You have to pay our media. Media is essential to our democracy, and we need to have ways for extracting and sharing the value that otherwise you, Google, are appropriating. Whether that's through taxation or regulation, fair point. But I think this speaks to the question of having global cooperative processes so that we don't have unequal conversations between sovereign governments and foreign firms.
Thank you, Rohinton. We have just under 2 minutes left. So if anybody has any closing thoughts before we finish the panel, now is the time. Ms. Kaljuran, would you like to give some departing remarks?
Yes, what I'm taking from this conversation, and what I think that the future of digital depends very much on humans. It has to be human-centered. We need consumers who understand, who are educated, and who make educated decisions. So human has to be at the center of digital services, artificial intelligence, and all the laws and regulations being drafted.
Thank you, Ms. Kaljuran. Chris.
So I just end where I started. We have to be careful as we think about this and think about the second and third order effects. You know, what happened in Australia was tried in Spain, I think, before, and I think Germany even flirted with it. And the publishers in those countries said, no, don't do that. That's going to hurt us. So we have to think about this in a broader sense, and we think about things like creating data stores that are run by the government. That has problems too. So let's not just think in the digital realm. Let's think about this in the larger public policy realm.
Thank you, Chris. 27 seconds, Avarna.
Thank you. Well, I would have to agree. I think that when we consider that regulating things like speech, like personal data, this is going to touch on key tenets of democracy or human rights if you're not in a democracy, like our elections, like who gets decisions. So all of this will need to be level-headed, depoliticized and thoughtful participatory processes to think about what is the best way to protect rights and regulate in the digital age.
Thank you. And the timer has run down to 0. Thank you all for joining us for this panel today. And we'll now be moving on to the closing session of the Colaba conversation. Thank you.
Thank you.
Thanks so much.